Hi, good evening, and welcome to the latest episode, if we can call it that, in Densura and Friends. And with me this evening, I'm really pleased to have once again Sarah Buxton. It's that old adage, you don't need any introduction, but of course that would give me nothing to do this evening, really. So by way of brief introduction, Sarah is very, very well known in the dental community for all the great stuff that she does. She's an employment lawyer, and advises a ton of practices. She's also very big on equality and diversity, which is really one of the major focus areas we're gonna have this evening. So Sarah, you're very welcome. Thanks again for joining us. If people have got any questions and they're watching live, then please do put them into the chat box or the questions, and we can deal with those. But other than that, Sarah, if I can hand over to you, and looking forward to what you've got to say.
It's lovely. Thank you, Kevin. Yep, thank you to Densura for having me again. It's always a pleasure to be here. We thought it was important to do a talk on associate agreements, what needs to be included, not only because of the recent development that happened last week that I'm going to go into,
Right.
but because we do deal with quite a lot of associate disputes, and quite often it is because of what's included or not included in the associate agreement. So I'm going to share my screen, and hopefully you'll all be able to see a PowerPoint, and
Perfect.
we'll go from there. Brilliant. The protected characteristics. I think it's important to start here because quite often in practice, a lot of people believe that self-employed persons are not covered under the discrimination legislation, and that isn't always the case. Quite often the discrimination legislation does protect self-employed persons, workers and employees. So just a reminder of the 9 protected characteristics. The first of these is sex, marriage and or civil partnership, and I've said this for quite a long time, it's not often that I deal with a dispute about marriage or civil partnership in the workplace, because I think socially and culturally we've moved on quite a lot from discriminating against people because of their marital status, but it is still protected in the workplace. Gender reassignment, age, disability, race, pregnancy and or maternity, sexual orientation and religion and or belief. And it is so important that everybody within the dental team are treated equally, and that you do not discriminate because of these issues. Now, the biggest payout in compensation under the discrimination legislation to date was in 2011, and it was a sexual harassment case, and the compensation awarded in that case was £4.5 million. So eye-watering amount of money. You need to be aware that not only with your self-employed persons can there be contractual disputes, and that I'm going to come into what should not be included in the agreement, but also you need to be aware of these protected characteristics. Quite an important one, because the development that we've been reading about last week in the employment tribunal is actually in respect of a self-employed associate. And this associate worked and was engaged by Roderick's Dental Care. Roderick's, as some of you will be aware, have got over 100 dental practices. One of their dental practices, the lease was actually coming to an end. And what they did was they looked at their associate agreements, and they saw that they had 3 months notice to provide to their associates, and they provided 3 months notice to an associate who was on maternity leave. Now, she has made a claim in the employment tribunal for discrimination in respect of maternity, pregnancy and or maternity, because the other associates in that practice were redeployed. So she suffered detriment, she believes, because she was on maternity leave. And what they're deciding at the moment in the employment tribunal is whether she satisfies the criteria as a self-employed person to move into the other types of status, worker and/or employee, where she will be able to bring that claim. And it's very interesting to read the judgments, because what they're saying is they pick up lots of characteristics, lots of conditions and indicators in there, which I'm going to talk about this evening, which are in there to protect you. Now, I've just mentioned the Employment Tribunal, and I think this is an important point to advise any of the practice owners out there to ensure that they have legal expenses insurance in place. So legal expenses insurance is an insurance product, and I'm not the broker here. So
you carry on.
Yeah, I'm not the broker, but I will always act in my client's best interest. And the issue with the Employment Tribunal is that if you lose the case, you do not have to pay the winning party's legal costs. So in some of our courts, so in the county court, you had to be really sure that your case has merit and that you can move forward with it, because if you lose, you have to pay the winning party's legal costs, which can be an eye-watering amount of money. That does not happen in the Employment Tribunal. So in the Employment Tribunal, not only is there the risk that you may have to pay out a huge amount in compensation, and I've already told you about the highest payout, 4.5 million. So there's the risk that you may have to pay out compensation, but there's also your legal fees that you have to pay. And what a good legal expenses insurance product does is it will cover your legal fees, any out of court settlement and or judgment. So I always say to practice owners, just consider your insurance policies and make sure that you are covered for an employment tribunal claim.
Yeah, I think, from my point of view, good advice, and I'm very happy to advise anyone on that.
Absolutely. Quite often, I think people don't realise the importance of it, because they believe I'm never ever going to receive a claim, or I'm going to do everything by the book. But 1 in 3 businesses end up with an employment tribunal claim, quite often spurious employment tribunal claims, and it can be incredibly expensive if you don't have an insurance product in place to help with legal fees and or making a settlement or paying out any judgment if that's the case. And as I've already said, I'm not an insurance broker, and I am completely independent from any insurance product out there, which is not often the case from a lot of HR advisors. So they will stop you trying to use your legal expenses insurance. But what you need to do is have a proactive HR advisor coupled with a good legal expenses insurance product, so that you can run your business in the way that you see fit. What's even more important in the dental industry is that your legal expenses insurance product needs to cover self-employed, worker, and employee status. And this evening is particularly focused on self-employed status, because we have associates and hygienists and therapists who tend to be self-employed. And I have come across products where practice owners believe that they've got the right product in place, the right insurance product, but actually when the associate makes a claim in the employment tribunal, they will say they're not covered because they're self-employed and not an employee, which can really catch dental practices out, because it's very unique as this industry. So just be aware of that as well. So self-employed status. This is something that, as long as I've been acting in the dental industry, I have been advising on, and people are always worried about self-employed, employee, worker, where do people fit? Now, there is no right or wrong. You will engage an individual depending on what is right for you and your business. And self-employed status for hygienists, therapists, associates, can work, but you just have to make sure that it is set up in the right way. And not only is it the contract that ensures that it's set up in the right way, but it is also the relationship that you have in practice. Now, what's nice about being self-employed is that there should be some freedom, some flexibility, and good work-life balance. And there's also tax advantages to being self-employed. So there's lots of reasons why associates will want to be self-employed. And lots of reasons why the practice owner would want to engage somebody in this way. With regards to self-employed status, they have very little rights under the law. So really what's signed up, what you sign in the agreement is the starting point and what each other's obligations are. So associates, make sure that you know what you're signing before you sign an agreement. I do understand the excitement of you've got a job, it may be one that you've been looking for and you'll just sign anything, but I think it's very important for both parties, practice owner and associates, to take advice and understand what they are signing up to. So in practice, we will find that there are different types of associate agreements depending on the type of practice that engages you. Private, NHS, capitation, or a mixture of the two. Don't be surprised if the advice is maybe have 2 associate agreements in place. So it may be that you run your business through a limited company, and that's the private element of the business, and your NHS contract is in your name as a sole provider, and therefore the advice is to have 2 associate agreements so that the associate can take part in the NHS superannuation scheme. Very important. And what you need to ensure that the 2 agreements marry up as well. I'm finding at the moment that there are quite a lot of contractual disputes because there are so many agreements flying around that nobody really understands what's in them, and they may have different terms. I believe that happens because people take a template agreement, try and fill it in, try and make it fit. And what they don't do is put something bespoke in place, which is right for their business structure and for their practice. So on the face of it, this private NHS capitation will be the 3 elements of how a associate is financially rewarded, but you may find that there's more or less depending on the business structure. So the most important indicator of self-employed status is the license fee. I have come across many associate agreements where this license fee has been removed. And when something is removed, it's usually because an individual didn't understand why it was included in there. Now, the license fee is the amount that the self-employed person pays to the practice owner, and in return, the practice owner provides them with their chair, their equipment, facilities, reception staff, maybe consumables, etc. The license fee varies from practice to practice, and it'll be whatever is right for you and your business. But it can be anything from 50%. But at the moment, I must say, it was always 50%. And then it went down, and it went up. The license fee went up to 60%, and now it seems to be creeping back towards 50% because obviously it's harder to recruit. But that doesn't mean it's correct. The figures, whatever the percentage is what is right for your business. I'm just speaking generally across what I see happening now, because let's say it's a 50% license fee. What happens in practice is that the associate is provided with 100% of the revenues that they gross. But in the associate agreement, there will be a clause saying that the practice owner holds that 100% on trust, takes their 50% for the use of the surgery and the property and the facilities, and then at the end of the month, once an invoice is raised, pay back the other 50% to the associate. And that is so important that that mechanism works, because it is the main indicator of self-employed status. If that license fee is removed from the agreement and it doesn't happen in practice, it does make it so that the associate moves from being genuinely self-employed to work at, and maybe even employee status, and then they get lots of rights under the legislation. So for example, they may be due holiday pay or sickness pay, etc. With license fee, the hardest at the moment to well, where I don't see it so much is in self-employed hygienists and therapists agreements, but it should be included if they are genuinely self-employed. So another key indicator of self-employed status is the right to substitute. So I'm an employee. I can't send somebody else in next week to do my job for me. If you're genuinely self-employed, you should be able to send somebody else in next week to do your job. And what's interesting about the update that we had last week with the case against Roderick's is that the judge in that case made it clear that it should be an unfettered right to locum, to substitute. It's understood that there are regulatory issues as to why the practice owner needs to know who's coming into their practice, but you shouldn't try and attach too many conditions onto the locum clause. For a lot of the cases where I've been involved in, whether an associate is genuinely self-employed or not, the right to substitute or the right to put a locum in place has really been the indicator where a judge has said, actually, they can't be an employee if they have the ability to do that. Holidays. When a genuinely self-employed person, you shouldn't really be controlling their holiday entitlement. And if you do, this is something which is seen to be more towards employee status. Employees are entitled to 28 days statutory minimum, and it's a controlling indicator. Having said that, I do appreciate that as a practice, you need to know when your associates are going to be around and not. But it may be a case that they have to provide notice of their holidays, but as long as they satisfy other obligations in your associate agreements, that you allow them to take as many holidays as they see fit. But quite a controversial one, because the commercial reality of running a dental practice is when you're booking patients in 6 months in advance, you need to know if your associates are going to be around or not. So just bear that in mind when looking at your associate agreements about whether it is something that you genuinely need, because if you can remove it, that is better for self-employed status. This is the amount that well, this is a tax case, and I wanted to stress the importance that being self-employed, you have great tax advantages. I'm not an accountant. Don't ask me how tax is calculated, because I won't be able to answer. But what I can explain is that one of the most important clauses in an associate agreement for the practice owner is what's called a tax indemnity clause. What that clause does is, in a scenario where the Inland Revenue decided that your associates or self-employed persons may be employed opposed to self-employed, it gives the practice owner the right to be able to then go to the associates and say, come on, you owe me some of this tax back. I've just paid your tax bill and some fines for you. Without that, Inland Revenue will look to the practice owner in that situation. For self-employed associates and hygienists, quite often I will be asked, do I have to have this in there? I want it removed, but there's not very many people who are successful in having that clause removed out of their associate agreements because of the significance of it. Now, this is a case, it's getting on a bit, this case now. It's quite an old one, but it's in respect of Weight Watchers, and the Inland Revenue took Weight Watchers all the way to the Court of Appeal, and Weight Watchers tried to claim that the leaders of their groups were not self-employed. The Inland Revenue was saying they're employed. And when the judge looked at the indicators of how the group leaders were seen to be, no license fee, so they were paid for the hours that they worked. They could not locum, so they could not put a substitute in instead. Weight Watchers provided them with marketing material. Weight Watchers provided them with training. They sourced their community centres where they would hold the groups, etc. And it was found that they were employed opposed to self-employed, and therefore Weight Watchers had to pay back £23 million in tax and fines. So again, if you need to ensure that you are put in the best position possible in respect of the tax tribunal, which is different to the employment tribunal. The two institutions do not work together, but you do need to make sure that you are covered in respect of tax claims. And the way that you can do that is by looking at your associate agreement and making sure that you do have as many indicators as possible in there for self-employed status. So vicarious liability. Another area where we've had some developments over the last 12 months. Time for me has just flown. It's probably even longer than that. So we've had a couple of cases which have been in the dental press. And again, we've looked at how we can protect and how this can be incorporated into the associate agreement. So vicarious liability is a legal term whereby somebody takes responsibility for the actions of somebody else. And we've used this as employment lawyers for years. The most common example where I would have looked at vicarious liability before the most recent cases would have been the Christmas party. And that's because at the Christmas party, people say things that they wouldn't ordinarily say in practice, especially after a few drinks. Going back to those protected characteristics, it may be that one colleague says something that's discriminatory to another colleague, and you may think as the practice owner or the employer, I'm not responsible for that conversation, but actually you are vicariously liable for that conversation because the Christmas party is still in the course of employment and you are liable for the actions of your team members. Now, this was extended to actually go a bit further in respect of self-employed persons in clinical negligence claims, where it was found that you can be vicariously liable for the clinical work of your associates. So what you do need to do is make sure that there is clauses in your associate agreement that protect you should that happen in respect of indemnities, so you can go back to the associate if you can find the associate and try and claim back the costs that it may have cost you. And here it's another place where I'll let Kevin speak a bit more about it, but again, making sure that you have the right insurance product in place, because when these cases hit, there wasn't a lot of cover in place to protect. So there's been lots of developments there. Also, what you do need to ensure is that going back to all right, we can put indemnities in there to protect you in respect of vicarious liability, but you do need to make sure that you have as many self-employed indicators in these agreements as possible, because the reason why vicarious liability was found to apply in these cases is because the judge found that the relationship was akin to an employment relationship. So we need to move away from that. And unfortunately, in the cases that we had, they had template agreements, so not very bespoke. They hadn't really drafted them to suit them, their practice and the relationship they were having. And also slightly different because it was an NHS practice. And one of the things that was picked up is the NHS targets. And that was quite controlling, to have NHS targets. And when I read that, for NHS practices, I just thought, well, what can you do? You need an NHS target in an associate agreement, because without it, we end up in disputes. We end up in NHS disputes about overperformance, should they be paid, clawback, and so on. So for an NHS practice, there's no way we can get away with a target without having a target. We've just had a case where NHS contract, and the judge looked and said, yes, there's a target, but I can also see, and there's emails and correspondence to suggest that that target wasn't imposed. So because it wasn't imposed, it wasn't controlling. And in this particular scenario, our client, practice owner, would have annual conversations. It was all in correspondence where they would agree a target, which I think is quite important, because the judge said, you know, you get a self-employed plumber, you would say to them, it's those pipes and that's what I need sorting out. So, and the plumber agrees to do that. But what you don't do is you don't impose the work on the plumber. And that's quite important here. And I think for NHS practices, just to make sure that we're not too controlling, I think we should look at not imposing a UDA target, but actually trying to have conversations with the associate about what they can do, and how much work they would like, which would really help with self-employed status. So disputes. The most disputes in practice where you need to make sure that you're covered is firstly where there's no written contract in place. I come across lots of disputes where there's a misunderstanding between the two parties, and the associate may think they have various obligations and the practice owner thinks that they have other obligations, and then they don't meet in the middle. So always make sure that you have a written contract in place. And as I said at the outset, it is so important that both associate and practice owner fully understand the clauses included in the associate agreement and the consequences of them. Big one there, money. Spend a lot of time with disputes in respect of monies, because quite often it may be associates are not paid correctly. It may be that they retentions are withheld when they should or shouldn't be. You can only withhold a retention if it's in the agreement allowing you to do so. It may be that they believe the retention's not being used properly. Notice periods. You've not provided me with the correct notice period, so I'm going to withhold some money. So lots of disputes about money, and ultimately you would want your associate agreement to set out what happens in those scenarios. And money not paid on time, or not paid within so many days, or the right amount not paid. Fixed term. There are a lot of practice owners at the moment signing up associates to fixed terms, because it is difficult to recruit. So they're wanting to retain their associates and self-employed persons, and they're doing this by trying to tie them into a contract. It's fine from a legal perspective, it should work. I do always say to people, just think about it, because you want to earn loyalty rather than try and fix them in to something where they may not be happy within 6 months. And do you really want someone like that in the team? But I do also understand the commercial considerations of trying to retain staff at the moment. The difficulty is, quite often, if an associate breaches a fixed term contract, firstly, you have to try and find the associate if you want to sue them, and they may have left the country. So I'm finding that is quite often the case, but sometimes commercially it's not viable to try and sue them. Fixed terms, I'm seeing things with sign-on bonuses where associates are being paid £5,000-10,000 and leaving, and that is actually still classed as a small claims, and you've got to really think about whether you'd wish to move forward with the small claims, because sometimes commercially it's not worthwhile. But you really do have to think about fixed terms and retention bonuses and the consequences if the associate breaches them, or indeed if the practice owner breaches them for the associate. And then finally, I do a lot of work with disputes. So the old restrictions and binding out clauses are not worth the paper they're written on. They are, as long as they are drafted correctly. We often find that associates are leaving and setting up in practice in competition or trying to poach patients. And I'm finding a lot of this at the moment, where associates are building a brand, which is great, because it's self-employed status. They're running their own businesses, they're building their own brand, great for self-employed status. And then they move practice and take patients with them, sometimes staff with them, or set up in practice, and it has a huge effect on the business that's been left. And quite often they haven't thought about whether they need to control or to restrict their actions. So we do things like, where does the Instagram account belong? Whose Instagram account is it? And when were those pictures taken? Were they in the practice? Do you want that removed? And so on. And because that's not in a template agreement that you might download, people aren't thinking about it because they're not thinking about what's right for their business. But we do an awful lot about disputes with restrictions and what's happening once a self-employed person leaves. So that's me. I'll stop sharing my screen there. So I'm happy to take any questions.
Great stuff. Well, first of all, thank you, Sarah, as ever. I mean, it's not getting any easier, is it? Being a practice owner, or even being an associate. But for practice owners, recruitment, finding the right staff, and then making sure you retain them, and then obviously making sure that you protect yourself. I mean, there's a lot to think about. So I'll come back to this again, but the whole issue of what we do in indemnity and what you do in terms of the associate contract very often dovetail in making sure that practices are properly protected and associates are properly protected. Couple of questions, really. I suppose one general one: are you seeing, in terms of trends, are you seeing any uptick in challenges to self-employed status? Does that come across your desk any more than you would expect? Are you seeing an uptick in that or not?
Yeah, absolutely. I think there tends to tribunal claims or county court claims to be either they tend to increase with what's going on in the economy, and when things become more difficult or money gets tight, we do see a rise in the type of claims. So at the moment there is an awful lot where there are disheartened or disgruntled, and some of them rightly so, associates, not always the case, who are looking to receive a quick buck. So there is definitely a lot of more cases generally. On the point about self-employed status, I do think there's a lot more of these going through the tribunal, because there 2 years ago now, the Uber taxi case was a big Supreme Court judgment that really set out the test for self-employed status in the Employment Tribunal. And even in that case, the key there was that the Uber taxi drivers moved from being self-employed to worker, and hence they had to be paid holiday pay and sick pay. But the key indicator was the fact that an Uber taxi driver cannot substitute. They cannot send somebody else in to drive their taxi for them. And I think the one thing that dentists will always have, and this is why hygienists and therapists worry me, because they don't tend to do it so much with hygiene and therapy, is that they will always have the right to substitute, and that's got to happen in practice as well. It's got to be the reality situation.
Right. Yeah, absolutely. I mean, we see it just in your point about general dissatisfaction. We've seen a huge uptick in terms of the number of complaints. We're about sort of 30 to 40% up on pro rata where we would have been last year. And I think that's just people are just dissatisfied with a number of things. So one question that's just popped in there is that I'm an associate moving into a limited company. What are the key things I need to look at in the contract? And who can I ask legally to check my contract before signing, please?
I could check your contract.
Beautiful one for you.
Yeah, that's my job. That's tends to be what I do. Quite often checking contracts for people and making sure that they're fit for purpose, or it's not even being fit for purpose. It's more having an understanding of what you are signing and making sure that it's right for you and the practice that you're joining. In respect of moving into a limited company, I take it that you are private dentists and not NHS, because that can play around with your superannuation. So I take it that you've taken advice from a dentally aware accountant. That would be the first thing that I would say, because from a legal perspective, it would be great if everybody was a limited company, because you'd have limited liability. So they could only sue you for your assets and everything that's in your limited company rather than you personally. But from a tax perspective and from the NHS superannuation, you do need to take accountancy advice to make sure it's the right thing to do. What you may find is that you, in your associate agreement, you personally will still be on the hook for your actions of your limited company. So you may find that you have an associate agreement where you personally are still named on there, because a lot of the goodwill and your clinical treatment and everything about being a dental associate is very personal. So you may find that the practice owner still wants you to guarantee the actions of your limited company, and the limited company will just be there for tax purposes.
Okay, well, that's great. And from Susie, if you have contracts in place which need to be reissued for all of the reasons you've discussed, what's the best process to follow to reissue? Should you provide notice, for example?
Yeah, I mean, in an ideal situation, you would hopefully be able to have I think one-to-ones is very important.
Right.
I think firstly, you can give a heads up to the team at the team meeting. Look, we're going to be re-looking at contracts and bringing them up to date with the current legislation and regulations. CQC expect you to annually review your contracts, because that is a well-led practice. So I always say to my clients, blame it on the CQC. So you can give them a heads up. The next thing is I would have one-to-ones, because I often find that if you just put them in the post or give them out in a team meeting, the team members will feed off each other. As if you have a one-to-one and explain to them, this is your new contract, read through it, go and take advice, encourage them to go and really understand the contract. come back to me when you're ready and let's get it signed. You may find that they read it through, sign it, and that's the end of it. You can put it in a drawer, and you've not had to serve notice. It may be that they go and take advice, or they look at a few bits and they want some things changing, or you'll have to come to a compromise with them. And quite often it's not, sometimes it's a lack of understanding why they don't sign it. Or it may be that there's a clause where they just want it watered down, or a condition attached to it, and you may be able to agree to it, and then again we can get it signed. The worst case scenario from your perspective as a practice owner is that you do have to serve notice, because that usually means that you haven't been able to compromise or come to an agreement over it, and it starts making me wonder, like, is that person fit for your team? What's their attitude? It's deeper than the legal in the contract. So that is the last resort in my eyes, serving notice to re-engage them on the terms that suit.
Yeah, I mean, it's difficult at the moment, isn't it? There's such a shortage of clinical staff around. You know, you're having to attract people, and I suppose it's just a note of caution, you know, not to go too far and not to give in to too many sort of conditions in terms of the contract. One question you raised earlier, you're talking about vicarious liability, which of course I know from the point of view of indemnity claims. But in the example you gave of someone misbehaving at a Christmas party and doing something that they shouldn't do, and they're a self-employed dentist, as a practice owner in those circumstances, have you got any liability for them, or is that just their personal thing?
No, you are still liable for their actions. So anybody who comes into your business, or the thing with the Christmas party is that people, or any social event, is that people do not realise that that is in the course of employment. So anything that is in the course of employment or within the practice, ultimately you can be liable for, whether they're self-employed, volunteers, a tradesperson coming in, whatever.
Right.
You really do have to make sure that the entire team are aware of equality and diversity. And you do that by making sure you have a good equality and diversity policy in place, and by ensuring that you provide equality and diversity training to the entire team, self-employed or not.
Right, okay. Okay, there's no more questions at the moment, but what I'd suggest is if anyone has got any questions, or if you're watching this and watching the recording, then please do send them either in to us at densura.com or to Sarah, and she's put up, we'll be putting all the contact details up after this anyway. But unless anyone's got anything else, really, Sarah, I'm just really grateful for that. I think it's really helpful advice to get people through this particular minefield and keep them safe. So thank you again, Sarah, and thank you everyone who's joined us.
Thank you.
Have a good evening.
Thank you. Good night. Bye.
Good night.